What is common between Bhagat Singh, Shashi Tharoor and Umar Khalid? What is common between them is that they have all had sedition cases slapped on them at some point in time. And the future of this law now hangs in balance as the Supreme Court is set to decide whether it should stay in the law books or not. So in today's episode of KYC, I'll tell you what the sedition law says and why have there been accusations of it being misused. Now, sedition is a pre-independence law. It was introduced way back in 1870. Here's the definition of sedition for you on the screens right now. And it's a mouthful, of course, but to break it down for you, see it as these 3 pointers: that there should be words, signs, visible representation, etc. that bring or attempt to bring hatred or contempt against the government, that excite disaffection or attempt to excite disaffection against the government. And conviction under this section can lead to a jail term of 3 years or even life imprisonment. Just to let you know, sedition was abolished by the United Kingdom in 2010. Now, our Supreme Court is hearing petitions challenging the law. But this isn't the first time that the Supreme Court is considering the fate of this provision. A 5-judge bench also did it in 1962 and upheld the provision in the Kedarnath case. The court looked into the relationship between sedition and the freedom of speech and expression under Article 19(1)(a) of the Constitution. Now, Article 19(1)(a) guarantees the freedom of speech and expression, as we know, and Article 19(2) lists down 8 grounds on which the right can be restricted. So basically, our right to freedom of speech and expression can only be restricted on these 8 grounds that you can see on your screens right now. Now, citing this article, the Supreme Court had then in 1962 said a very important thing. It had ruled that a person can be charged with sedition only if there is incitement to violence in his speech or writing or an intention to create disorder. But critics have always claimed that this link between violence and disorder is what is missing in the cases filed under sedition these days. Just to let you know, now the Supreme Court is also considering whether this Kedarnath judgment would need a relook. There was another very prominent case on sedition law, and this is especially prominent because the Supreme Court ruled that even raising Khalistan Zindabad and Raj Karega Khalsa slogans at a public place wasn't sedition. This was a 1995 case, but the court said that casual raising of slogans once or twice by 2 individuals alone cannot be called sedition. Imagine that happening right now. But cut to the last few years, we've had cases filed under Section 124A at the drop of a hat. For example, we recently saw 3 Kashmiri students being booked for sedition for allegedly celebrating Pakistan's win against India in the T20 World Cup. There was another sedition case that was filed against 8 people for raising the slogan Pakistan Zindabad in Jharkhand. We know that several journalists have also of late been booked under sedition. Also, to let you know, between 2016 and 19, for example, the number of cases filed under sedition rose by 160% even after the rate of conviction dropping to 3%. And this is the sort of misuse that the petitions have tried to highlight in the Supreme Court. They have also spoken about how the law causes a chilling effect on free speech and is unreasonable restriction on freedom of speech and expression under Article 19(1)(a) of the Constitution. That's all I have for you right now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.